All right, ladies and gentlemen, let's talk about Chapter 9, the jury. As an introduction, in serving to temper the power of the government to judge individuals to be in violation of the rules of society, the jury lets members of society itself determine if a person is worthy of condemnation. Although it is generally agreed that juries serve an important function in the criminal justice system, of the past several decades, they have come into some disrepute. So we'll talk about that and exactly what the responsibility of the jury is and why sometimes they aren't looked at favorably. History of jury trials. The concept of juries is not an American concept. It actually started way before. Um, as a matter of fact, it came from Europe, but before that, of course, kind of in the medieval times, and before that, they had something called trial by ordeal. It was a process by which a defendant would be required to perform a perilous task, such as walking across burning coals or removing a rock from boiling water. If the defendant emerged without harm, he was judged innocent. For surely God intervened and provided protection. If the defendant were injured, he was adjudged guilty. So thank God we don't do that now. People will be walking around with burnt feet and burnt hands. So over time, trial by ordeal went away. They realized that was stupid. In England, juries were under the control of the crown, and the same process was brought to the colonies. So when England came over here, of course, the legal system came over here as well, and that brought juries to the colonies. The problem was the juries were almost handpicked and chosen by the crown or people or people who were loyal to the crown. So you can only imagine how unfair trials were. It's almost as if the deck was already set before trials would begin. Um, the right to trial by jury and the protection it provided from the strong arm of the government became a factor in the colonists declaring independence from England. As I said before in prior chapters, when you look at the Constitution and all the rules of law, it's essentially a grievance form or a list of grievances um, that America had against the British government. So essentially, everything that Britain did, they didn't want that here. Of course, Article 3, Section 2 of the United States Constitution states that trials of all crimes, except in cases of impeachment, shall be by jury. And such trial shall be held in the state where the said crimes shall have been committed. The Sixth Amendment guarantees that a person accused of a crime shall have the right to a trial by impartial jury of the state and district wherein the crime shall have been committed. The jury was not to be stacked by the government. The defendant was not to be uprooted and sent to a distant part of the country for a trial that occurred in the jurisdiction that he was already in. So, all right. Of course, there are a number of matters associated with the modern use of juries that were not spelled out in the Sixth Amendment. So it's kind of created by case law. Three questions: What crimes involve the right to jury? The jury's permissible and required roles and actions during the criminal trial. What are those? And the composition of the jury. What is the size? What is the demographic? So let's start off with the role of the jury. Under the law, the jury's role is to process. The jury's role in the process is that of fact finder. So they are to take the facts and determine from the facts that they're given and that are presented to them to determine guilt or innocence. The jury has virtually unlimited discretion in how it interprets the evidence and establishes the facts of a crime or of a case. I'm sorry. There are some restrictions on the jury. One is that the jury is only permitted to consider the facts presented in court as evidence. So if it didn't come to them or wasn't presented in front of them in evidence at that trial, they can't consider it. And that's one reason why a lot of people don't understand, and certain juries rule against, kind of, they don't understand why what they're hearing in the media doesn't match up with the jury verdict, and that's because the media, um, when we have these high profile cases and they're talking about what's happening, we don't realize there are issues with a lot of evidence does not come in to a trial because of the rules of admissibility and the rules of evidence. So sometimes the jury is limited in what they have to make their decision. Um, Number two, jurors are not permitted to conduct their own investigations, look up information in the newspaper, or read scientific journals or other scholarly materials to weigh the validity of any evidence. So once again, they can't do their own independent investigation. They can only use what is presented to them. Um, Jurors must only consider, this is number three, jurors must only consider the evidence that has been properly admitted in the case. If items raised at trial were excluded by the judge, jurors must disregard what they actually perceived, even if they actually heard it. Um, I think the book talks about unringing the bell and the fact that you technically cannot unring a bell, just like you can't unsee something or unhear something, right? But the jury is tasked with excluding from consideration anything they hear that's not admissible, so they have to act like they didn't hear it. So it is hard, but like I said, they're asked to unring the bell, and they have to. So they can only consider what's admissible. Jurors number four. Jurors cannot consider the defense's failure to testify on his own behalf in their fact determination. So the Fifth Amendment gives defendants the right to remain silent, even during the trial, not to say anything. So jurors can't hold it against a defendant that he didn't choose to testify in his own defense. And number five, the jury is not permitted to consider possible punishments that may result from their verdict. So they're not permitted to make the decision based upon what the person's punishment may be. They just have to make fact determination. Is this person guilty or not based upon the facts? Once the jury has established the facts of the case, the jury's job is to apply facts to law. The law is provided in the form of jury instructions provided by the judge at the close of trial. Two general components of jury instruction. First, you have the general instructions, stuff that talks about the burden of proof, the presumption of innocence, and the defendant's right not to testify, and certain other procedural things dealing with being a juror. Then two, the second is that's when we talk about the elemental, or what would I say, the substantive portion, where they talk about specific elements of crimes and affirmative defenses that are at issue in the trial. So they give you instructions on what your duty is as a jury, and then they give you the rules that are going to apply, or the law that applies to this specific case based upon what the person's charged with. So if it's a murder trial in North Carolina, they're going to give you, in the substantive part of the jury instructions, it's going to give you the definition of murder in North Carolina based upon North Carolina statute that you have to apply to the case. All right. What are the limits on the right to a jury to a trial by jury? It was not until the 1960s that the right to jury trial was made applicable to states. You have the case of Duncan v. Louisiana, 1968. The right to trial by jury for serious offenses was fundamental right and applicable to states. For prosecutions of petty crimes, however, the court ruled that there was no right to a jury trial. But the case failed to define what petty crimes were. Then a couple years later, 1970, Baldwin v. New York came out, and it said no offense can be considered petty for purposes of the right to trial by jury where incarceration is over 6 months. And so it kind of defined what petty offenses are. Petty offenses are offenses that involve potential period of imprisonment of 6 months or less. All right. Then you have Muniz v. Hoffman from 1975. That state says, regardless of how large the monetary fine may be, if the offense involves potential period of imprisonment of 6 months or less, it is considered petty. So, in other words, the fine, let's say the possible statutory fine that would be imposed if a person is convicted has no bearings on whether or not the case is petty or a petty crime or not. So it's all just based upon what the crime is and what the possible imprisonment time is, not the fine. Now we're going to talk about jury size and unanimity requirements. Jury size. The use of 12 in the United States colonies was generally accepted as the correct size to fairly sit in judgment at a criminal trial and was the accepted standard at the time the nation was founded. The use of 12, however, is not constitutionally mandated. Williams v. Florida, case out from 1970, the Supreme Court ruled that juries do not have to be made up of 12 people to be constitutional. The case of Bailu v. Georgia, 1978, says that 6 was the lowest number of jurors permissible. So I guess the final answer to come from the question of how many jurors would be between 6 and 12. So then there's a unanimous verdict requirement. The requirement of unanimity was also firmly established in England and the United States. Having all jurors agree on a verdict serves to legitimize a decision, thereby providing society a sense that the verdict must be correct. Several statutes permitted the use of non-unanimous verdicts in criminal prosecutions. And Opodaka v. Oregon, the case from 1972, Oregon's 10-2 verdicts in non-capital cases did not diminish the function of the jury. Then in Johnson v. Louisiana in the same year, 1972, Louisiana was permitted the case permitted 9-3 verdicts. Of course, in Birch v. Louisiana in 1979, it said when a jury of 6 is used, the verdict must be unanimous. So when they use that minimum amount of jurors, the verdict must be unanimous. They can't split. Of course, in North Carolina, we are a unanimity state, so our jurors, it must be unanimous. And so that what that means is, besides Oregon and Louisiana, all other states require unanimity. The selection of jurors. First, you have stage 1, and that's the developing of a master list. A master list or jury wheel. It's a list of potential jurors within its jurisdictional boundaries who can be chosen at random to report for jury duty as needed. So we're going to talk about how they come up with the list. The old school way of doing it was the key man system. Under this system, court clerks and jury commissioners would consult with civic and political leaders for input on who should be placed on the master list of potential jurors. Predictably, these so-called blue ribbon jurors were not representative of the community and included disproportionately high number of middle and upper class white males. So of course you kind of see that happening when you got politicians and men at the top that pick the jury pool. It's going to essentially be their friends. So what's that lead to? Especially this is in a 1960s era case, or the 1960s era cases. As blacks began gaining civil rights, the makeup of juries involving cases of black defendants came under scrutiny to determine whether the defendant were being denied their Sixth Amendment right to an impartial jury and their 14th Amendment right to equal protection under the law. This caused the key man system to fade away. So, not many jurisdictions, if any at all, use the key man system to come up with their veneer or their jury pool. All right, Jury Selection and Service Act. It's legislation that mandated that all litigants in federal courts are entitled to a trial by jury, have the right to jury selected at random from a fair cross section of the community in the district or division wherein the court convenes. All citizens must have an opportunity to serve on juries. Master lists must be drawn in each jurisdiction from the list of registered and active and actual voters, as well as from other representative resources or sources. In the case of Taylor v. Louisiana, got a lot of Louisiana cases on juries. This mandate does not require that each jury actually be representative of the community, but rather that there be no government actions or practices that serve to systematically exclude a segment of the community. This is essentially altogether killed the key man system. So they use stuff like voter registration lists, driver's licenses, utility and phone directories and bills, and fishing and hunting licenses. Names are selected from the master list. The number is determined by the clerk of court or the jury commissioner. Names from the wheel are selected at random and sent summonses to report for jury duty at a specific time and place. Some jury wheels yield low rates due to the staleness of the list. That means the people change addresses. The list hasn't been changed in some time, and when that happens, of course, they send their mail out, but it's never served. It never goes to the right person. It may go to who lives there now, but the person that is sent to is named. Let me see. All right. Okay. Jury wheels are also low yielding due to statutory exemptions based upon the profession of citizens. People like lawyers, law enforcement, court personnel, and public safety workers are usually exempt from jury duty. Right. Low jury yields also stem from the inconvenience related to jury service. You got missing work, transportation issues, parking costs, the low amount of jury compensation because they don't pay them much. They might think it might be like $10 a day or something crazy like that. It's been a while, so I don't know what it is now. Actually, I've never served on a jury, but I've had jury trials. And of course, no one wants any of that. They don't want to lose out on money. Let's see. Okay, then we have stage 2. And this is moving from the veneer, which is the jury wheel or jury pool, to actually having a jury panel, those people that you bring into the courtroom to select from, but right before the trial. The jury pool or veneer is the group of individuals who report for jury duty at a given time, anywhere from dozens to hundreds, depending on the number of trials they have. So they can predetermine the number of jurors they think they're going to need. All right. Once arrived, potential jurors are asked to fill out questionnaires and administrative paperwork and receive information regarding parking, scheduling, and the payment of fees for jury service. Usually held in the jury assembly room until a set number of members are randomly selected and called to report to the specific courtroom. This group is now. Okay, I'm sorry. Uh, this group, once they get called into that, once they get called in, is now the jury panel. Um, so once they arrive, fill out paperwork, they're sitting there and they're no longer the wheel or the veneer like where they're out in the community. Now been brought in for jury duty, so they're now a jury panel. And then well, I'm sorry. Actually, once they go from being the veneer, I'm sorry, in the courthouse to now being called out, and a certain number of people being asked to sit in the courtroom where the trial is to be picked. That's when they become the jury panel. Um, and the jury panel generally ranges from 20 people for a 6-person jury to 40 plus people for a 12-person jury. Now, stage 3, voir dire. At this point in time, 12 names are then randomly called from the jury panel to sit in the assigned seats in the actual jury box. So they call the initial list of jurors, and at this point, it then becomes a process of elimination to try to get the jury that's going to favor your side of the case. People that may, so you ask them all types of questions, and this is what we call the voir dire. And of course, voir dire in French means uh, to see and to speak. They are then the people, the jurors or the jury panel is then subject to voir dire as a method of process and elimination to determine the final number of jurors and alternates. Voir dire, it is a jury selection process whereby the jury panel is asked a series of questions by lawyers and the judge in order to determine whether the potential jurors are unbiased and can decide the case fairly and impartially. So you have when you strike people from the jury, we call those challenges. You're challenging them and you want them gone, you want them replaced. It's not nasty. We don't have an attitude. We just say, Judge, I'd like to do a peremptory challenge for juror number 1. So, challenges for cause. These are unlimited opportunities to strike a potential juror who cannot be fair and impartial. So when they say, you're asking them questions of voir dire, personal questions, about personal life and things that happen to them, so you can get an idea of who they are. So once you get an idea of who they are, then you might ask them some tougher questions. But at this point, it's about figuring out whether they're going to be able to serve as a juror, and be fair and impartial. If you can't be fair and impartial, you can't be a jury. So I've actually been in trials where a person said something on purpose to be not fair and impartial just to get off the jury, and it was kind of stupid. Okay. Reforms to the jury system. We talked about. Okay, I'm sorry. Challenges. Let me go back. Like I said, challenges for cause are unlimited opportunities to strike a potential juror who cannot be fair and impartial. So, based upon the answer to the question, if they're not fair and impartial, you can what they call challenge, or which is essentially striking them for cause. Then you have preemptory challenge. This is a limit. This is where you have a limited opportunities to strike a potential juror without giving any reason at all. So just because you don't like them. So that's why jury selection is so important, because I have a client sitting beside me and I want to choose people that have either been through stuff that he's been through, or people that see it his way. People that will believe his story. So you have to know your client's story as a defense attorney, and you have to know it enough to kind of put it in the mind to be able to select the jury that's going to be more favorable in his story. Now we're going to move on to reforms in the jury system. Allowing some of the reforms are allowing the jurors to take notes. Of course, in a jury trial, if you're impaneled as a as a juror, and you're sitting there listening to all this stuff, all this technical stuff, and you can't jot anything down. That's kind of terrible. Now you're gonna have to make a decision based upon what you think happened or remembered, as opposed to your notes. So they allow some jurisdictions allow jurors to take notes. Over the course of a trial, jurors are asked to remember a lot of testimony and evidence, as I said before. This assists their ability to recall and leads to higher probability of the case being decided upon based upon the actual evidence and not lapses in recall. Allowing juror, I mean, allow, and then there's another kind of innovation that some jurisdictions use, and that's allowing jurors to ask questions. Normally, it's not them raising their hand and asking their question verbally. It's about them writing their question down and presenting it to the judge. The judge can determine the admissibility of the question, so the question still has to fall within the rules of evidence. And then they may even convene as opposing counsel with the judge to figure out if they're going to allow the jury to ask that specific question. Let me see. Oh yeah, so questions are asked by jurors are subject to evidentiary admissibility standards, as I said before. Evidentiary admissibility standards. Questions are given to the judge, like I said, in writing, and the judge asks for the jurors. If certain questions can't be asked due to rules of evidence, the judge should and normally does explain why the question it can't be asked. It's inadmissible. Next, we have providing written copies of the instructions for each juror. So, of course, that would be very, what do you call it, convenient if you could walk into a jury trial and you have a notebook so you don't have to share everything. You can open and say, oh, yeah, on this item number 29, and you can talk and make a decision as a juror. Jurors are asked to apply a large body of law and copies of instructions for each juror. Jurors are asked to apply. This allows them to have a quick means of referencing the rules and instructions. Then we have providing jurors with trial notebook. In recent years, courts have begun providing jurors with individual trial notebooks that contain items such as jury instructions, a list of witnesses with photographs, and copies of key documents and exhibits to have been admitted into evidence. Then the use of jury reform. So we talked about some things they're doing to reform juries, but all this stuff isn't used everywhere. A lot of this stuff isn't used in North Carolina. In North Carolina, they allow jurors to take notes. I've never been a part of a trial where they were able to ask questions through the judge. Never been a part of a trial where they were given copies of instructions. They might give one or two table copies so they can read, but never one for each person. Let me see. Then providing jurors with the trial notebook. Definitely never seen that before. The implementation of jury reforms varies greatly across the country and from state to state. Last but not least, we're going to talk about jury nullification. This is one of the powers of the jury. So you got to think, once the jury is a panel, that jury is very powerful. It's 12 people that have the important task of deciding the fate of a defendant. So they're sitting there and they get to brainstorm. I think 12 people is always better than one, right? It's like strength in numbers. But one of the powers that the jury has is they have the power to totally ignore the law that they're applied in the case in determining guilt or innocence. And I'll read it out to you. Jury nullification. When a jury, based on its sense of justice and fairness, refuses to abide by the law and convict in a particular case, even though the defendant is unquestionably guilty under the definition of the law. So this person may be guilty based upon the definition of the law, but the jury may feel like they were right or it will be unjust to punish them. And jury nullification is actually a strategy. I've never really gone into it heavy into my trials, but I know you can strategize and nullify the jury. It's almost like getting to like your client no matter what he did. or in what he did, if he was somehow, if not totally justified, at least he was kind of justified, and the average human would understand why he took the action he took. Um, so in that situation, if they understand, they can say, well, we don't want to convict him, and you don't have to. Now, that they can't use jury nullification in reverse. They can't ignore a law to convict someone, but they can ignore a law to acquit someone. So just remember that's how it works. The jury cannot, like I said, cannot use nullification power to convict where the evidence is convincingly exculpatory. Once the case goes to the jury, they possess the power to disregard the law and do what they believe is just in acquitting a defendant. So that's jury nullification. So that is chapter 8. So I think you have everything you need for this chapter. Of course, go through the book, www.sagepub.com, and you can actually type in and do a search for the book. Like you said, do a little bit of searching. I can't hold your hand and tell you everything, but you go in there and look. You got the portal for the book. Then you got tabs like for test and review, and that's honestly where I get some of my test questions from. So that I'm just giving you that as kind of a bump or as an assist so that you can get out here and so that you can get out here and learn and assess yourself. So that's why I give the book website like that, because I want you guys to do well in this class, and I want you to be able to go and check yourself to make sure you know what you're talking about. So without any further ado, you guys be good, and I'll see you for the next chapter.